So I want to turn it over to Trey Ford, Marcia Hofmann, and Kevin Bankston for their fun presentation this afternoon.
Good afternoon. Thanks for coming out and joining us for this session on legal landmines that stifle security research and how to disarm them. There are three of us here today. My name is Marcia Hofmann. I am an attorney and I am in private practice, and I work on issues involving privacy, security, hacking-related matters, encryption, some copyright. And I am also a non-residential fellow at the Stanford Center for Internet and Society, and I'm special counsel to the Electronic Frontier Foundation. Trey, would you like to introduce yourself?
Sure. Hey guys, my name is Trey Ford. I serve as Global Security Strategist with Rapid7. For the last couple of years, I was working full-time here at Black Hat, and basically here to connect with you guys and discuss a little bit about how hacking is affected by law.
Hello. Whoa. Hi. I'm Kevin Bankston. I'm a law-talking guy who focuses on surveillance, online privacy, free speech, and such. I used to sue the bastards with Marcia back at EFF. Now I wonk the bastards in Washington, D.C. at a place called New America Foundation's Open Technology Institute.
So this is our plan for today. We're going to spend the first 20 minutes or so giving you a sense of some of the laws that we consider security research landmines. And we're going to cover, 5 laws? Very briefly, just to kind of give you a sense of what they're like and where some of the problem areas are from our perspective. And then we are going to play a game. And we're hoping it's going to be very interactive. This is a bit of an experiment for us, so we're excited. Hope it works out well.
Very non-standard.
Very non-standard. What we're going to do is we're going to, together, generate some random scenarios to try to walk through how these laws apply. And the idea here is to get everybody thinking about where the problem areas are and how we might start to think about fixing these problems. And so at the end, our goal is for everybody in this room to kind of be in a position to think about how we might actually get to a position where we can fix these problems. For the sake of logistical efficiency, I think it might be best if folks could come forward and maybe concentrate on that side of the room, if you want to. I think that'll make the interactive part of it a little easier for us. Okay, so let's get started. The standard disclaimer that, of course, you'll hear from any lawyer is this is not legal advice. This is information. We're here to educate you about the laws at issue and the problems, and hopefully that's beneficial and useful for you. But this is, of course, not a comment on any particular situation. And if you have questions about your own circumstances or research that you want to do, you should, of course, talk to a lawyer. Come talk to me. Come talk to Kevin. There are others here as well, and I'm sure everybody would be happy to help you out. Okay, so the first landmine we're going to talk about is the Computer Fraud and Abuse Act, which I think a lot of you have probably heard of before. It's been in the news a lot over the past couple years. So that I can just kind of get a sense, how many people in this room know about Aaron Swartz's prosecution? All right, a very good number. How many of you know about the prosecution of Andrew Auernheimer, aka Weave? Okay, a good number of you. Okay. So the CFAA is a law that was passed in the mid-'80s at a very different time. And it has a number of prohibitions, but the one that has become the biggest problem is one that is actually fairly simple. It makes it illegal to intentionally access a computer without authorization or in excess of authorization, and thereby obtain information from any protected computer. And so this is the concept that's the problematic one, this idea of without authorization or exceeding authorized access. You would think on the face of it, it's pretty simple, but the problem is the law doesn't actually define what authorization is or how one would indicate authorization. The statute has no definition of the term authorization or without authorization. Interestingly, it does define the concept of exceeding authorized access, and basically what that means is you are authorized to access the computer, but you are obtaining or altering information that you don't have permission to obtain or alter. So we do know that, but we don't know about without authorization or how that's indicated. And so the courts have really struggled with this. What makes access unauthorized? Does it mean that you've breached some sort of a technological barrier that's meant to keep you out? Does it mean that you're using a technological means of accessing information that the computer owner just didn't anticipate, didn't think of? Does it mean that you're accessing information that actually you're allowed to access, but then you take it and use it for something you're not supposed to use it for? Is that unauthorized access? And these questions have really tripped up the courts. One of the reasons why this is so problematic is because the CFAA has some really harsh penalties. And so if you're convicted under this law, it can be a really tough situation. The type of unauthorized access that I've been talking about here, as a general matter, if you violate the law, it's the first time you've ever done it, it's a misdemeanor. And that means that it's a relatively low-level offense. You could spend some time in jail, but it won't be more than a year. The consequences for your life are relatively low. But there are circumstances when it can become a felony, and a felony is a much bigger deal. That's prison time in excess of a year, and there can be other consequences for your life, like you might have trouble getting a job after that, or you might not be allowed to vote in certain places. So that's a much bigger deal. Even a first-time violation of the unauthorized access provision can be a felony when you do it with intent to profit, when the information you obtain is worth more than $5,000, or the act is in furtherance of another illegal act, or it's a repeat offense. And it's worth mentioning in the prosecution against Aaron Swartz, he was not looking at a misdemeanor, but rather he was looking at felonies, and that's because the government argued that the academic articles that he was downloading using MIT's network were worth more than $5,000 in the aggregate. And in the case of Weave, while this would have been his first CFAA violation, he was also looking at a felony because the government was arguing that when his co-conspirator wrote a program that harvested a bunch of email address and ICC ID pairings from AT&T servers, and then we've passed that along to a reporter, that violated a New Jersey state privacy law. So that became a felony. So as you can see, it's a fairly easy thing for the government to make an argument that even a first-time offense is one that deserves some very harsh penalties. Another thing that's very important about the CFAA is that it's this weird statute where not only is it a criminal statute, which means you can go to prison if you violate it, but it's also a civil statute, which means that somebody can sue you for money damages if you violate this law. And the thing that's really problematic about that is that if you're dealing with a civil case where, normally one private actor is just suing another guy, this is just a beef between two people or, a company and another company, a company and a guy, a court looks at that very differently, I think, than when we're talking about a situation where the government has decided that they are going to prosecute somebody for committing a harm against society, and that's deserving of prison time. And yet, the cases that are decided just between two people become precedent for these other cases. And so I think what happens is judges find themselves in a position where they're thinking about the wrongs in the context of two people sorting out a dispute, but that becomes precedent for what the government can do to pursue a person later. So that's pretty crazy. In the civil context, private companies can sue for injunctive relief, which means basically a court order saying you can't do this anymore. Or they can sue for damages, for money damages, to basically compensate somebody for whatever loss they've suffered. Something that's interesting to note is that a private party is in a position to sue if it can show $5,000 of loss. And loss is basically like out-of-pocket costs needed to remedy the situation. And so what's scary about that is that lots of things could constitute loss. For example, somebody discovers a vulnerability and reports it to a company. If the company wants to turn around and sue, they could say that the cost of fixing that vulnerability perhaps might be loss, right? I've even seen a case where a company argued that the costs that it had to pay lawyers to investigate whether it could sue and then ultimately sue constituted loss. So basically, that means companies are in a position to manufacture loss pretty easily if that's what they're trying to do. Okay, so that's the CFAA. I'm now going to turn and talk a little bit about another law that you may have heard of, the Digital Millennium Copyright Act.
Marcia, let me jump in real quick.
Okay.
Real quick, some of you are raising your hands. Be aware that right now we know we're creating a lot of questions, and we're going to be exploring these fairly aggressively shortly. So right now is the time to be starting to ask those questions. Make a note. We'll hit them in a little bit, all right?
So the DMCA is kind of a cousin of the CFAA. You'll see that it's actually pretty similar. The basic prohibition of the DMCA, section 1201, says that no person shall circumvent a technological measure that effectively controls access to a work protected by copyright law. Okay, so what are works protected by copyright law? We're talking, music, ebooks, movies, on DVDs perhaps, code. Code is copyrightable, right? So even just basic code is something that's at issue here. Now, this is a law that, while it's meant to protect copyrighted works, this is different from copyright infringement. You can actually circumvent some technological measure and gain access to a copyrighted work and do nothing with that work. You don't have to infringe it at all, but you've still broken the law under the DMCA simply by circumventing that access measure. And so, I think it becomes very important. What does this mean to circumvent a technological measure? What is a technological measure? Under the decisions that we have from courts, I think it's pretty clear that DRM, digital rights management systems, count. Encryption counts. Authentication measures count. But then we have questions. What about code obfuscation? What about proprietary protocols? What about chain of trust signing? Do these count as technological measures? And I think that is very much up in the air. Now, unlike the Computer Fraud and Abuse Act, the DMCA actually has some important exceptions that everybody here should know about. I'm not going to get into them in great detail, but if you do work that you think might be affected by the DMCA, it's worth knowing about these. There is a reverse engineering exception, but it's fairly narrow. It basically applies only when you're working to make code interoperable with other code. There's an encryption research exception. There's a security testing exception, but only if you have the permission of the computer owner or the network administrator. And then there's also this weird exception where if you have a device that collects information about you online, you can circumvent for the purpose of disabling that collection about yourself. Very little known. Most people don't think about that one. So the DMCA, frankly, I think is a little scarier than the Computer Fraud and Abuse Act because the penalties are, I think, even tougher. Again, this is one of those weird hybrid civil and criminal statutes, so it has the same problems with precedent. On the civil level, somebody can sue you and get injunctions, again, keeping you from doing this type of thing in the future. They can get actual damages, meaning, the actual loss that they suffered, a compensation for that. But this law also has statutory damages. And what that means is there's this provision that says, if you, party who's suing, decide that you don't want actual damages to compensate you for your loss, we'll just say that for every violation of the law that you've suffered, we'll give you somewhere between $200 and $2,500 at the judge's discretion. And if the offender is one who's a repeat DMCA violator, then the judge has the discretion to actually triple that amount. And so you can imagine a circumstance where if somebody actually is violating repeatedly or distributing tools to let others violate, and it happens quite a bit, you can really rack up the penalties. And there are criminal penalties as well for violations of the DMCA that are willful and for commercial advantage or private financial gain. And in situations like this, you can be fined up to $500,000 and be imprisoned for 5 years for a first-time offense, double that for repeat offenses. So $1 million fine and maximum of 10 years in prison. So what I would say about these two laws is it's not always clear which actions are illegal. The vagueness of the pivotal language tends to lend itself to selective enforcement, meaning that, for example, the government could say, we really don't like this person, and so while we let this slide a lot, we're really going to use this tool to go after a person for stuff that may be actually not the type of conduct that these statutes are meant to prohibit. And because of the harshness of the penalties, if you get the book thrown at you, you really get the book thrown at you. Okay, so now I'm going to turn it over to Kevin, and he's going to tell you about some other landmines.
Hey guys, so I'm here to talk about a law called the Electronic Communications Privacy Act of 1986. So you know it's quite up to date and really deals well with the vagaries of today's technology. And basically this law, I mean, all joking aside, this is a law that is important to protecting online privacy. It's the law that your EFFs and your ACLUs use when they're, say, suing the NSA or suing AT&T or trying to make sure that the government gets a warrant when it wants to seize your email or track your cell phone. But it's also broad and vague enough that it poses a real challenge, I think, to researchers. So it's 3 landmines in one. There are 3 big parts of the law, and I'm going to blow through this pretty fast. You'll probably miss a few details. It's okay. I just want you to get the general sketch, and then some of it will become more clear when we get into the game. So there's the Wiretap Act, which governs real-time monitoring of the content of someone's communications. There's the Register Statute, which governs the real-time monitoring of non-content information or metadata about a communication, or dialing, routing, addressing, and signaling information, as the statute says. And then the Stored Communications Act, which governs the privacy of communications that you store with a communication service provider like your Gmails or your Facebooks or your ISP or whoever. The Wiretap Act is the big one. It prohibits interception of a communication, that's acquiring with a device the contents of a communication, either an electronic communication or a wire, meaning telephone communication. It also governs eavesdropping on oral conversations. If someone were to plant a bug in your house, that would violate the Wiretap Act. It also prohibits disclosing or using illegally intercepted contents. And it's a very, very serious statute. It is a felony to wiretap someone. You can get up to 5 years in prison or fines or both. And like the statutes that Marcia was talking about, you can also just get sued for it as opposed to being prosecuted for it. It is a civil as well as a criminal statute. And you can get sued not just for actual damages, but also statutory damages. That is, damages that the plaintiff will get just automatically if they can establish you wiretapped. And they're really high. It's $100 a day per person or 10 grand per person, whichever is greater. So I say holy statutory damages, Batman, and I say that for a specific reason. If you've seen Dark Knight, where Batman opened the mics on every cell phone in Gotham City to try and catch the Joker, you know, if you assume Gotham is about the size of New York and you assume that a vast, number of those phones were in private spaces when that happened, we're looking at tens or hundreds of billions of dollars of statutory damages if Bruce Wayne had got caught, a tab that maybe even he could not pay off. In the digital age, this isn't just attaching alligator clips to a phone line. You're doing stuff that could implicate the privacy of hundreds or hundreds of thousands of people. As Google learned recently, in a case that did not go its way, you are probably familiar of the Google Wi-Fi sniffing case where they were using their Street View trucks, vans, to map wireless access points for their mapping services. But in the process, and they say accidentally, actually ended up capturing a lot of unencrypted Wi-Fi traffic and storing that. And so there was a class action suit against them, Joffe v. Google in the Ninth Circuit, which is basically the West Coast. And I'm not going to go into the details. It's a very confusing area of law, but there is an exception to the Wiretap Act that says if you're wiretapping something that's a communication that's readily accessible to the general public, that's okay. And in the case of radio communications, something is considered readily accessible to the general public if it's not encrypted or scrambled. So Google said, hey, we were just intercepting unencrypted radio signal. That's readily accessible to the general public. The Ninth Circuit disagreed and said, actually, no, Wi-Fi isn't radio, as Congress intended that term to be meant in 1986. And therefore, you just need to go by, is it readily accessible to the general public under the plain meaning of those words? And we think that, grabbing radio signal with software that I could Google for right now and install on my laptop and immediately start running somehow is not generally accessible, readily accessible to the general public. So I say WTF to that. For a more in-depth examination of that question, actually, you can Google for the video of me debating Matt Blaze, moderated by Jennifer Granick at DEF CON 2 years ago. It's a really interesting issue. But the upshot is, all you guys who were running Wireshark at 13, like, you probably committed a felony under this law. And you can see cert denied at the end of the case. What does that mean? That means Google tried to get the Supreme Court to review the case, and the Supreme Court said no. So this is about as close as you can get to very good law, short of a Supreme Court ruling saying this is correct. There are some key exceptions to the law. First off, consent. If you get consent from one of the parties to the communication, then it's okay to intercept the communication. Note, some states have an all-party consent rule for their state wiretapping statute. There's an exception for providers who intercept your communications in the ordinary course of their business of providing you communication service. Similarly, there's a provider exception for them to intercept your communications as necessary to provide the service or protect their rights and property. This originated with the phone companies doing various intercepts to try and combat fraud. And so unconsented debugging of your network or spam or virus or attack filtering on your own network, even without consent, is probably okay under this provider exception. Beyond that, And then, of course, there's this readily accessible to the general public exception. You heard how that went for Google. In fact, Google had a pretty bad 2013 because there was also another really big wiretap case against Google in regard to Gmail. Google scans the content of your Gmail so that they can better target ads at you based on the content of your email. There was a class action against Google saying, hey, we think that's an interception of the content of our emails. And there was a decision by the Northern District of California, not as high as an appellate court, but an important district. All the tech companies are there. And the court actually, and Google argued, this is in the ordinary course of our offering this Gmail service, which we've made clear is subsidized by the fact we target ads at you. And this is just the way the service works. So it's ordinary course of business. And by the way, also, we have consent. We have implied consent from the users because we've explained in our materials that this is happening, and yet they still use the service. But the court said no. We think the ordinary course of business exception is really narrow and only applies to interceptions that are instrumental to the transmission of the communication. And also held that the terms of service were not clear enough in saying that, yes, Gmail scans your email content for targeting ads, and therefore there wasn't implied consent. So one of the lessons here is ideally express consent, someone like clicking a banner saying, yes, I know I'm going to get intercepted. But at the very least, if you're relying on implied consent, make sure your statements of what you're doing are really, really clear. Next up, we have the Pen Register Statute, which is sort of like the Wiretap Statute, but for non-content metadata. If you're wondering why these words, pen registers are from the phone era, and they are devices that collect the numbers that you are dialing, and a trap and trace collects the numbers that are dialing you. But the Congress expanded this very phone era statute to the internet with the Patriot Act in 2001. Thank you, Osama bin Laden, for that. So the Pen Register Statute is different from the Wiretap Act in a few ways. First off, there is no general consent exception. There is a consent exception that applies for providers. So if the provider gets your consent to run a pen register or trap and trace, that's okay, but there's no general consent exception. So for example, running your own caller ID, as opposed to a caller ID service that is provided by the provider, could actually be not a felony, but a federal crime. So too could tracking someone's cell phone by putting up antennas and trying to locate them. This is based on the DOJ's own surveillance manual, where they say, we think that tracking a cell phone implicates this statute, and therefore we need to get a court order for that location tracking. Luckily for you, if you're doing anything that implicates this statute, it is only a misdemeanor statute. There is no felony pen register violation, and there's no civil cause of action, so no one can sue you for violating it. So it's relatively low risk, but it's still a risk. And it can be used to enhance other penalties. Marcia was talking about the CFAA, where if what you were doing was to further another illegal purpose, that could enhance the felony. If your CFAA violation also enabled a pen register violation, then you could get a felony enhancement. Third and finally is the Stored Communications Act. It's a lot like the CFAA. It prohibits unauthorized access to computer systems, but in particular, it prohibits unauthorized access to your communications when they're stored in electronic storage with a communications provider. Like the Register Statute, it is a misdemeanor, except, like under the CFAA, that misdemeanor can turn into a felony if it's a repeat offense, if you're doing it for commercial advantage or private commercial gain, if you're doing it to maliciously destroy someone's files, or to further any other illegal act. And again, like several of the other statutes, it also carries civil penalties. Someone can sue you if you break into their email. And again, there are statutory damages. Not just, you could get actual damages, but in no case shall a person be who is entitled to recover get less than $1,000. So if you do something that implicates the email privacy of 100 people, then we're talking about $100,000 automatically, regardless of whether you actually cause damage. So ECPA, it's a serious deal, like CFAA, but at least probably if you violate this statute, you can't be double charged for it under CFAA, thanks to the work of folks like Marcia in a case called U.S. v. Gioni, where they actually tried to say, oh, someone broke into email? Well, that violates CFAA misdemeanor and Stored Communications Act misdemeanor. Combine those to make a felony. And actually, we've done pretty good at pushing back in the courts and saying you can't actually enhance based on the exact same conduct. You have to have been doing it to further some other act. But so those are the three big ECPA landmines. And now that we've laid out the 5 key landmines, we're going to move on and ask you, shall we play a game? Let's play a game.
All right, so I'm going to break this out a little bit, kind of describe our strategy. Statute of limitations varies based upon each of these laws. We're not going to jump into that. Did you guys enjoy that legal course? Everybody clear and straight on law? Yeah? Clear as mud. So if you're like me, you're going to have a lot more questions than you have answers right now. Rather than starting legal discussions right out the gate on current researchers that are doing work at Black Hat right now, or in the last couple of years, what we're going to do is use you for random number generating. We're going to run through a short list of activities, actors, targets, motives, and wildcards. So, Laura, first off, give me the first couple numbers you've got drawn from the deck. 7, 6. I need 3 more. 8, 2, 4. All right. 7, we're going to be brute forcing. The actor is Aaron Schwartz. Number 8, the target's the Chinese. The motive is debugging or improving system security. And the wild card is along the way we're dropping O-Day. So we've got Aaron Schwartz, brute forcing what? The Chinese? Oh wow, we really got a doozy here. For the sake of improving system security. Oh my gosh.
So the Chinese is deliberately ambiguous. That could be the Chinese government, that could be a Chinese business, that could be whatever. Let's say it's the Chinese government. Let's say Aaron Schwartz is brute forcing his way into a Chinese system in order to debug or improve their security. Apparently he wants everyone.
He's an altruist.
He wants everyone to have good security. And then he's going to drop an O-Day about it.
He's going to drop O-Day, yeah.
Okay. This is not going to go well for Aaron.
Wait a minute. He's doing this for good purposes right off the bat. Does any part of this sound like a problem? You guys ever run brute forcers? Don't raise your hands. That's
Actually,
not
let's
funny.
take a vote. How many of you think something like this should be illegal?
Show of hands. You can raise your
Show
hands
of
for
hands.
this one.
How many think it shouldn't be illegal?
It's definitely questionable. and
Under
interesting.
U.S. law?
Illegal under U.S. law. No.
No.
All right, so Aaron is brute forcing. Let's say he's trying to push his way into a mail or communication system in China. What's wrong with that?
Okay, well, so first off, you said good purpose, and I think one of the lessons here from the legal lesson is just because you have a good faith reason for doing what you're doing is not going to get you off. It may mean that you're only charged with a misdemeanor. Meanwhile, if you're doing something in bad faith, if you're trying to do something really nasty, then you very well might get a felony enhancement. It sounds like this would probably be a misdemeanor violation of the CFAA. And I think one of the object lessons from this particular fact pattern, assuming that the Chinese that he is hacking are in China,
Right.
is that although the CFAA is a domestic U.S. law, it protects computer systems outside of the United States as well as inside the United States. Basically, a protected computer under CFAA includes computers outside of the U.S. so long as they are used in commerce with or communicate with computers in the US, which is most computers. So yeah, and then he dropped an O-Day, which means everyone's going to know about it, and someone's probably going to come after him, quite possibly the Chinese themselves suing him in US court.
Let me interject real quick. Now, we're talking about dropping O-Day here. A moment ago we talked about, he's an altruist, and so he's going to make a good faith effort. So using small, less than legal terms, what does good faith mean, and where does that fit in with O-Day? Do we want to go there?
So I'm thinking maybe this is a scenario where Aaron feels like the Chinese government is not likely to fix this problem if he just tells them directly. So he feels like he needs to air this information publicly to put pressure on them to fix it, right? Which is something that we see sometimes. And, from my perspective, I think that full disclosure, it certainly ups the ante. Not necessarily from a strictly legal perspective, because if this is unauthorized access or what have you, that has already happened. That ship has sailed by the time he's doing full disclosure. So if he has committed a violation of the law, that has happened, right? But I think full disclosure is something that comes into play and really can up the ante when somebody is deciding whether they want to pursue it. Whether they want to file suit or whether the government might say they want to come after it, because I think that there is an argument there that perhaps he didn't have the best interests of people in mind, and his actions were more harm than good.
You have a real quick question. Go.
Ooh, hackbacks. There is currently no hackback exception to the law, although there are some in Congress who would like to see one. That is an ongoing debate about whether and how the law should be changed to allow offensive measures against those who you think are attacking you. But when I say who you think, I'm pointing to the attribution problem. That server in wherever that seems to be attacking you could actually be, that attack could be routing from somewhere else, so you may end up blowing up the system of some innocent person who just got owned themselves.
All right, we're rolling forward. Laura, next numbers. 41615. 4, we're doing location tracking. The actor is an academic or proper security researcher. Let's see, the target is his current employer, obviously because the researcher's a male, because I'm a jerk. The motive is corporate espionage against his own employer, mind you. So maybe they're going to be going to launch a stealth startup. And the wild card is going to be that the victim actually has no monetary damages. I don't know how that's possible.
Okay. So let's play this out. We have an academic security researcher. He is tracking the location of his current employer. So let's read that to mean he's tracking the location of other academics at his school.
Okay.
And he's doing it to try and figure out what they're up to, because he's a competitive dude.
There you go.
If he's a dude. But he ended up unsuccessful. He didn't make any financial gain out of this. No one was harmed by it.
Has he done anything illegal? Guys, let's ask the audience. Is anything illegal about this? He's spying on other researchers because he's competitive academic research. I've got one hand and a handful of nods. The rest of you are kind of shrugging.
Depends how he's doing it.
Well, let's say he put up a few different antennas around the school that pretend to be cell.
They look like Wi-Fi access points and a number of other things.
But I'm sort of basically he's doing it the same way that a variety of commercial actors are tracking when you walk into Phil's Coffee.
Ooh.
No permission. Assume no consent unless we say consent, and there's nowhere where we say consent.
That would have been.
That is a good point, though. Consent fixes pretty much anything,
except in this case, because what this probably violates is the pen register statute. Because as the DOJ's own surveillance manual says, tracking people's cell phones is a pen register. And yet the only consent exception in the pen register statute, as I pointed out earlier, weirdly, is a consent exception for providers. So if the phone provider were tracking your location with your consent, that would be okay. But he can't actually get effective consent even if he wanted to. And so the thing is, though, this is a misdemeanor and no civil cause of action. So even if he were found out, which he might not, The only legal risk would be that a prosecutor comes after him for a misdemeanor, and most federal prosecutors are not going to go after someone for just a misdemeanor. However, if there were something else they could charge him with that was related to this, they might tack it on to that and maybe get a felony enhancement from it.
All right, let me flip the scenario before we go random. I don't want to call out the Tor research specifically that was submitted and pulled, but let's say this researcher was testing stuff on Tor. I mean, the only real way to research Tor traffic is to take a look at live traffic.
So you're making it a network sniffing.
Yeah, we're going to network sniffing.
Yeah, we're going to network sniffing now.
Let's go
So
there.
academic researcher doing network sniffing.
Because it's competitive.
Because he's competitive.
Because I'm a jerk.
Do you want to?
Yeah,
No monetary
I mean,
damages.
offhand, that would not appear to satisfy any of the. I mean, first, that would be a wiretap if he is capturing the traffic coming out of the Tor exit node. That is the acquisition using a device of the content of an electronic communication, or in this case, probably many electronic communications. He doesn't have consent.
Because it's easy to
He is a provider. He's providing the communication service. He's one
running
of the
an exit
Tor
node.
runners,
Right.
Tor node runners. However, then the question becomes, well, is he doing it to protect his own legal rights or property, or to maintain the service, or debug the service, or keep it secure, or prevent fraud? Or is it necessary for him to do this incidental to providing the service? And the answer to all those questions is no.
Well, it makes
He's
sense,
doing
right?
it for research.
Consent's really easy to get from, hundreds or thousands of anonymous users, right?
So this actually highlights one of the key problems, I think, which is there is no researcher exception for the Wiretap Act, and one can imagine some fairly beneficial research that could be done around the Tor network, but getting close to that is pretty legally toxic.
All right, next group of numbers. Oh, sorry, go ahead. Quick question.
Did you catch that?
I think I caught it. The question was, well, what if he's filtering for illegal content? Is that a way of, or what?
He's troubleshooting. He's trying to maintain service. Okay.
I mean, certainly there would be an argument there, and one could expect a variety of providers would make this argument that if they were like, say, I don't know, searching for hashes of child pornography, as in a news story that came out this week, one argument that could be made would be that's protecting our own rights and property because possession of child porn is a strict liability offense, and we're trying to protect ourselves against liability for transiting that child porn. So like that might fit the provider exception, for example. But I think generally just trying to scan for potentially illegal material would be probably broader than most courts would read that exception.
I also think if we're talking about an academic researcher who has set up a Tor exit node for the purpose of doing this research, it's probably unlikely the provider exception would really help them out. Yeah.
So, one more?
One more.
One or two?
Laura, next numbers. 564. 56431. All right. So we're accessing someone's email. The actor is, again, Aaron Schwartz, the internet's boy. Target is a corporate rival. Oh, this is perfect. Number 3, the motive is security research, of course. And the wild card is he's using a white and black terminal because he's, when it goes for discussion, he's going to look like a hacker, clearly.
This was a fact that was used in an indictment?
No, a search warrant application. Several years ago, EFF had a case that involved this college student in Boston who was a computer science major, and the local police started investigating him because they thought he might have been behind sending some hoax emails. And so they applied for a warrant to go seize his computer and various devices, which they did. And then EFF challenged the warrant and got it invalidated. And it was interesting because when the police apply for a warrant, they have to make a showing to a judge that there's probable cause to believe that a person's done something illegal, right? Something criminal. And the facts that were cited in the warrant application included the fact that he was a computer science major, that his peers thought he was pretty technically sophisticated, that they asked him at times to help them fix their computers, and also that he had 2 operating systems on his computer, including one
artifacts
that had a black background with white text and a command line. So this was evidence of criminal
Just to check
behavior.
for criminal traits. Anyone
Can't
in this
make this
room
stuff
follow
up.
that in any way, shape, or form? Don't even bother raise your hand. I'm going to assume it's all of you guys. All right,
so do we want to, since we already did a corporate rival, do we maybe want to tweak this to a system used online, say like Gmail? So he's like testing the security of Gmail, and in the process, he accesses someone else's
email. So let's talk about how he got in there. Was he using stolen credentials? Was it something that was found on a password dump? Was he brute forcing? Did he sidejack someone's session? He's got into somebody else's email. Doesn't much matter how, does it?
I don't think it matters much how. I think...
you guys have never run Fire Sheep or anything else like that, right? Nod your head and smile. Yes, no.
Yeah, please don't. No. Yeah, don't nod your head.
So I think this is an interesting situation where if the police decided they wanted to go after this kind of thing, they have two options. They have the Stored Communications Act because it's email stored with a provider, or they could choose the Computer Fraud and Abuse Act because it's accessing a protected computer and obtaining information. This is exactly one of those situations that Kevin mentioned earlier where at times the government has tried to combine these two things, kind of smush them together, where each would be a misdemeanor. Basically, the idea would be, well, we'll just kind of bootstrap them together and we'll make them a felony. And because the conduct that's being targeted here is basically the same conduct that violates both statutes, as Kevin mentioned, we got a really good decision in the Fourth Circuit saying you can't do that. You have to pick one law or you pick the other, but you can't just combine them to get a tougher penalty.
And so I think the other main takeaway from this is even if his motive was innocent security research, he just wants to find out, is Gmail secure? And he discovers, not really. That would not prevent him from getting prosecuted or sued by Google for that matter.
In spite of a good faith effort or a discussion or taking it to CERT or anybody else, he's already broken the law.
Yeah. And the difference it would make would be, though, he would not get charged with a felony.
Oh, good. So he would spend at least, less than a year in prison.
Yes, it would be a misdemeanor. It would be a misdemeanor. I'm sorry?
I would say at that point that's consent. If you are testing on your own account, I would say that's consent.
It's kind of challenging because when you're fuzzing, you always know where you're going to land, right?
Yeah, it might depend on the particular facts. I mean, Google might argue that he's accessing parts of their system that he was not authorized to access. But if he's accessing, but in terms of the Stored Communications Act, it's probably like, yeah, he's accessing his own stuff.
So we're going to move very quickly because there's a mountain of hands up. Rebecca had hers up. We'll go to Katie, and then after that, we need to talk a little bit about certain things you think might improve some of these laws.
Okay.
What would happen if it was not an email system, but something that had either default user credentials or null password that no one had changed?
Default creds or null password, because there's a lot of SCADA and other fun stuff with no creds, right?
Or
anonymous FTP. That's not even logging in.
Well, my sense is that if we're talking about a default password that hasn't been changed, that's basically like guessing a password, right? And if you guessed somebody else's password, I think that would be a violation of the law. And so, I think the circumstances are slightly different, but I think probably a court would tend to treat it like you're guessing someone else's password. Do you agree, Kev? Yeah.
Katie, did you have one as well?
So you guys are talking about the hypothetical, but you're using Google, which is a real company, as an example. And one of the examples that came up was, what if they access their own email? Well, if they access a test account, that is actually within the bounds of Google's published bounty program rules.
Right.
So in reality, I just wanted to kind of bring this back to what Google's program actually has, which is the provision saying, do your best good faith effort not to violate the privacy of other users when you are testing on our service. And that's a good way that a lot of organizations like Google have provided a way for security researchers to do their research safely and also ask them directly not to violate the privacy of their other users. So they're not in that position. And in Google's case, they offer that.
Right on.
Awesome.
So, Marcia, Kevin.
Katie, do you want to?
Gotcha.
Hi, so I was just saying that you were using a real-world example of a real company, but in the case, hi Steve. In the case of Google, they actually provide a direct call to action for researchers testing their live services, saying do your best faith effort not to violate the privacy of another user, and you may be eligible for a bounty. So I just wanted to clarify, considering there was this kind of a lot of hypotheticals going around in Google's actual case, and a lot of online services that offer security researchers, I guess it's amnesty from prosecution. It's under these circumstances. Do your best faith effort not to violate the privacy of other users. Microsoft was actually the first major corporation to do this in 2007, where we said if you disclose an issue to us former us, sorry, I'm former Microsoft. Still getting used to it, 9 weeks out. Anyway, but yeah, 2007, Microsoft was the first major corporation to actually declare this, even before we had a bounty program. Former we.
So I think it's worth noting that this highlights that there is a lot that companies themselves can do to try and lessen the chill, as it were, in place of or in anticipation of or in the hopes of getting changes to the law. While we're waiting for changes to the law, there are a variety of steps that companies can take to try and make research less of a landmine-y situation.
Yeah, and policies like Google's, which other companies have too, I think are a really great way for a company to sort of channel and say, make it clear that they're not just kind of looking to bring the hammer down on anybody and everybody they could, right? They're interested in learning about vulnerabilities, and to the extent you might be nervous about the fact that they could have an aggressive reading of the law, it's something you shouldn't worry about so much, because they're letting you know that they're not just looking to prosecute or rather to refer to law enforcement or to sue anybody that they could sue.
So with 4 minutes remaining, what kind of thoughts do you guys have on the type of axes or variables that could be introduced to current legislation as it stands that would create a new layer of safety to help facilitate conversations about vulnerabilities, about research?
Well, I think there are a number of ways we can think about how to improve things. I'd actually be very curious to know what you all think about this. One thing we can do is try to more precisely define exactly what is illegal. And some of you may know that Representative Zoe Lofgren has introduced a bill called Aaron's Law that would be, if passed, a significant improvement to the CFAA by making explicit that you have to actually breach a technological barrier in order to have access without authorization. So, that's one approach. Another idea might be to add basically exceptions for certain people doing certain things, like security researchers, for example, or those who have good faith in one way or another. So those are ideas.
Yeah, definitely Aaron's Law, which would sort of clarify what counts as an unauthorized access and would also avoid some of the double or quadruple charging we've been talking about, which sort of just puts that much more pressure on, puts that much more chill on. I think the pen, this is not an official policy position, I'm just brainstorming, but on the pen register statute, it would seem that it might make sense, it would be consistent with the Wiretap Act and with the way technology works now, to have a general consent exception that isn't just useful to providers, but is useful to anyone, so people can do, consented to research on people's metadata. I think the Stored Communications Act actually strikes a pretty good balance, speaking generally. As far as the Wiretap Act is really scary. And I want a really strong Wiretap Act. I'm a civil libertarian, and it's the same law we use to try and keep the government in line. But this unencrypted Wi-Fi thing is problematic at the very least, and I think it's worth Congress having a discussion about whether and how they might want to clarify or change the law on that score. We could talk about a research exception. There's been a little bit of academic work looking at what that might look like. Part of the problem with a research exception is you either draw it so narrowly that it's not very useful, or it's so broad that it becomes a huge loophole to a really important privacy law. One way of addressing that, and this is just an idea I had this morning while we were preparing, is just as we have felony enhancements if you're acting in bad faith, with the wiretap statute, maybe you could have a felony de-enhancement, like be able to knock it down to a misdemeanor if you can prove that your purpose was security research. And so have an exception, not to the law, but an exception to getting charged as a felon for that violation. And also perhaps have a similar exception in terms of the statutory damages, such that if you're a researcher, you can only get sued for actual damages that you cause rather than Bruce Wayne level damages. And that's zero.
So,
we are at zero.
Parting shots. For those of you that probably have run Wireshark or other tools or done some level of sniffing, please don't raise your hands. Pointedly, I hope this was helpful. I hope you learned a couple of things about the current status of law. Anybody discover anything new that they weren't really aware of? I want you guys to be aware that there are organizations out there that are working on helping educate legislators and other key officials on what the law currently means, what it means to us, what we're afraid of. And there's a coalition being launched to try to help organize the community and industry efforts on that discussion. If you want more information on that, come on and talk with us. Kevin, Marcia, thank you.
Thank you.
Thank
Thanks,
you.
guys.
Thanks, everybody.